Good afternoon, everyone. My name is Oscar Escoto. I'm an immigration attorney here in Dallas, Texas. Today I want to talk to you about a new memorandum that was issued by the Department of Homeland Security. So earlier today, Secretary Alejandro Mayorkas issued a memorandum to ICE and other DHS offices instructing them of new priorities related to immigration enforcement. Now, this memorandum was issued because, as stated in the memorandum, there are about 11 million undocumented immigrants in the United States, and immigration said they don't have the resources to deport everyone, so they're going to focus their priorities on those who they deem priorities for immigration action. Now, in terms of enforcement action, this relates to everything to whether someone is detained by immigration, whether they're placed in removal proceedings with an immigration judge, and whether they're ultimately deported from the United States. So this is a very important memorandum, and I'm going to break it down for you today. Now, under this memorandum, Secretary Mayorkas outlined 3 priorities for immigration enforcement action. Now, the first priority are those who are deemed a threat to national security. And under this ground, immigration is going to look at people to see if they were engaged in or suspected of terrorism or espionage in the United States. Now, the second priority is those who are deemed a threat to public safety. Now, this is really the broadest ground, and this is really where it's a concerning ground because there's been a change in policy. So under current policy, individuals who have been convicted of an aggravated felony were at risk of being deemed a threat to public safety. Now, an aggravated felony, it's one of the most serious types of crimes under U.S. immigration law. Now, under this new policy, immigration has outlined that they removed the language related to aggravated felony. Now, they're going to look at to see if whether you have committed serious criminal conduct. Now, what's concerning about this is that they don't define what serious criminal conduct is. They don't list what crimes would constitute that type of conduct. Now, under this priority, immigration is going to look at aggravating factors and mitigating factors, and they're going to do so because they're going to apply a totality of the circumstances approach, which means they're going to look at everything to see whether that individual is a threat to public safety. Now, this is where it's important that you speak with an experienced immigration attorney who has the experience in fighting deportation in order to show that your family member is not a threat to public safety, right? Because immigration is going to allow you to submit documents to show, for example, rehabilitation or other positive circumstances that would outweigh the bad, which is mainly the arrest and things associated with the arrest. So again, immigration is going to look at the whole picture to see whether that individual is a threat to public safety. Now, the third and final priority are those who are deemed a threat to border security. Now, under this priority, immigration is going to deem someone a threat to border security if that individual was apprehended at the border while entering the United States illegally, or if they were apprehended in the United States after entering the United States illegally after November 1st, 2020. That date's very important because if someone entered the United States illegally before that date, they will not be a priority under this memorandum. Okay, so again, this memorandum is very important because it relates to whether immigration is going to try to deport someone from the United States. If you have any questions about your immigration status or about your options to become a U.S. resident or a U.S. citizen, I invite you to give us a call at 214-764-9234. I'll review your case in its entirety to see what options you have and to fight your deportation. Thank you, and you have a great day.